There was a real showdown in court, and I take the showdown straight away on the touch screen. Justice Kulendi says, in the case at hand, what will be the substantive constitutional breach in respect of the respondent's conduct? Justice Kulendi puts the question to Godfred, the former Attorney General. He says, Mr. Dami, let me ask you, in the case at hand, what will be the substantive constitutional breach in respect of the respondent's conduct? The respondent being the president, by the way. The respondent is the president. The applicant is Asifwa. The respondent is the president. Then Godfred says, my lord, the failure to give the Chief Justice notice. So Justice Kulendi says, what will be the substantive constitutional breach in respect of this? And says it is the failure to give the Chief Justice notice. That's what Godfred says. Simplifies the matter. Then Justice Kulendi continues. It is a question of time as to when the notice be given. Show us anywhere in Article 146 where the time is set as to when the notice to the Chief Justice ought to be given, as such violation will be a manifest constitutional aberration. Justice Kulendi was piling pressure on Justice Godfred to demonstrate where is the constitutional breach. Show me the constitutional breach. Is it, what is the point? Article 146 says what? Does it say when? At what time? It doesn't say. That's Justice Kulendi's question. Let me read it again. It says, it is a question of time, comma, as to when the notice be given. Show us anywhere in Article 146 where the time is set as to when the notice to the Chief Justice ought to be given, as such violation will be a manifest constitutional aberration. Godfred says, the Constitution is silent on that, and that is the essence of the constitutional issues before this court. I like the banter. The judge says, show me where the thing is. The lawyer says, it is not there. That is why you are here. The purpose of the Constitution, the Supreme Court, is to give clarity to things that are either not in the law that ought to have been there, or things that lend themselves to 2 or 3 interpretations. That is the essence of the court. If there was a black and white situation, Article 146, we will not be here, my lord. We will not be here. We are here, and you, the law, your lordships, are empowered with experience and learning and teaching that can help us to be able to go through this process in a way that a constitutional court works. That was the banter between Justice Lord Kulendi and Godfred. But as if Professor Mensah Bonsu was listening to both of them, she then entered into the fray with Justice Srem-Sai in this way. She said, the right to be heard is a constitutional right, and Article 23 requires that administrative justice should respect this right. Address the court on this, learned Attorney General. Address the court on this. So she makes a substantive statement and says, listen, the right to be heard is a constitutional right. And Article 23 requires that administrative justice should respect this right. Please address the court on this one. And then Justice Srem-Sai, the Deputy Attorney General, says, my lords, the right to be heard has been provided in the procedure outlined in Article 146. Hence, the issue is at what time the enjoyment of this right is to be respected. At what time the enjoyment of this right is to be respected. And then Professor Mensah Bonsu says, should the enjoyment of this right accrue after the respondent, the Chief Justice, has been tried in the court of public opinion? Srem-Sai says, my lords, I rest my case. So they are talking about rights. Professor Mensah Bonsu says, it is a right for everybody to have the right to be heard. Show me how this right should be enjoyed. He says Article 146 provides that the right can be enjoyed. But it doesn't say at what time the right should be enjoyed. You see, the president gets the petition, sends it to Council of State. The argument is that president gets the petition, send it first to the subject before the Council of State can have the petition and what the subject says, so that they can come to a conclusion of a prima facie. But you don't send to the Council of State only one side of the story and ask them to do a prima facie. This is the conversation going on. And they are saying that where, at which point? And Professor Mensah Bonsu is saying that, okay, if you're asking me at which point or that the Constitution is at which point, are you suggesting to me that it's okay for you to give the document to the person after you have tried the person in court of public opinion? That is to say, after everybody has seen the petition and is gone to Council of State, is it at that time that you are going to give the person the right to be heard? After the public has seen, after the Council of State has seen, after they may have prejudged the matter, after they may have made their opinion, is it at that time that you are going to show to the subject? This was a conversation between Professor Henrietta Mensah Bonsu, who was on the minority side, writing the minority opinion of 2, and Justice Srem-Sai, who is the Attorney General, Deputy Attorney General, and Deputy Minister for Justice. Justice Srem-Sai, in answer to the rhetorical question by Mensah Bonsu, said, "My lords, I rest my case."